No criminal case in Colorado is under more scrutiny than Tina Peters. Now, one angle to reduce her sentence may be evaporating. As President Trump punishes the state for refusing to free her and Governor Jared Polis considers clemency, an appeals court signaled late last week that a sentencing error could reduce Peters' time in prison. The judges suggested that Peters was convicted and sentenced to a 15-month term on a felony that should have been a misdemeanor. Well, now our Marshall Zellinger has learned that's because that misdemeanor did not exist at the time of the crime.
One of the arguments made in Tina Peters' appeal of her convictions was that a felony conspiracy to commit criminal impersonation charge that came with 15 months in prison should have been a misdemeanor.
That's a clear error.
Her attorneys argued the language in her indictment and the jury instructions described a misdemeanor in state law and not a felony. Colorado's Court of Appeals judges questioned the state about this last week.
It was one word, might, and it was already...
Yeah, but that one word distinguishes it from a felony to a misdemeanor.
And in this case, made an extra sentence, 15 more months in the Department of Corrections that couldn't have been given had it been a misdemeanor conviction.
But it turns out that misdemeanor did not exist when Peters committed the crime in 2021. It was a felony at the time.
The law that was in effect at the time the crimes were committed is the law that applies.
9 News legal analyst Scott Robinson confirmed our review of state statute. Peters was charged with felony conspiracy to commit criminal impersonation for a crime that happened between May 23rd and May 27th, 2021. She was charged with a felony because that's how the statute read at the time. In July 2021, the governor signed a misdemeanor reform law making changes to many criminal statutes, including criminal impersonation. That new law with all those changes took effect on March 1st, 2022.
There was no misdemeanor criminal impersonation on these facts when the crime was committed. So the instructions to the jury were accurate.
The conspiracy to commit criminal impersonation charge is about the ID badge she got for a man named Gerald Wood, but then allowed someone else to use that badge to gain access to Mesa County's election equipment. The language of that felony charge said the impersonation might have subjected Wood to a violation of law. Today, that language is for a misdemeanor.
A statute is not retroactive unless lawmakers specifically say it will be.
And when the 2022 law changes went into effect, they were not retroactive. According to Scott Robinson, because the charge is now a misdemeanor, the judge in Mesa County who sentenced Peters could have taken that into account when determining the sentence instead of applying the felony sentence. He could have had discretion to consider, well, since today it's a misdemeanor, maybe I'll sentence you to this.
Boy, it sure would have been useful if the prosecutor up there for the state had these facts at her disposal and could have brought it to the attention of the appeals court as opposed to just getting flogged on that issue for 10 minutes.
I went back and looked through the filings, and it was in the initial appeal, and the state defended it that it was a plain error, like legal language. They didn't argue it wasn't an issue because it wasn't a law at the time. They were arguing as though there was a mistake somewhere along the way, but that the defense at the time from Peters never objected to it during the case.
Also today, her social media team is saying online that she got roughed up in prison last night. She got attacked by another inmate. What, if anything, do we know about that?
We have reached out to the Department of Corrections. We're hoping to find out something by the end of today. We don't have anything official yet, but we're working on getting to the details of that.
All right, Marshall, thank you.